Primary sources: the Homestead Act of 1862. By public domain. Adapted by Nuzula Staff, January 6, 2020. Introduction. The Homestead Act was enacted during the Civil War in 1862 to encourage westward migration. It applied to any adult citizen or intended citizen who had never fought against the U.S. government. They could claim 160 acres of surveyed government land in the West. Claimants were required to improve the plot. They could do so by building a home and cultivating the land. After 5 years on the land, the original filer was entitled to the property, free and clear, except for a small registration fee of $18. The title could also be acquired after only a 6-month residency and some small improvements. This was as long as the claimant paid the government $1.25 per acre. After the Civil War, Union soldiers who fought for the government could deduct the time they had served from the residency requirements. This act was included in the Republican Party platform of 1860. However, support for the idea began decades earlier. Even before 1787, under the Articles of Confederation, the distribution of government lands generated much interest and discussion. 270 million acres, or 10% of the area of the United States, was claimed and settled under this act. The act was not a solution to poverty. Few laborers and farmers could afford to build a farm. The necessary tools, seed and livestock, were expensive. In the end, most of those who purchased land came from areas quite close to their new homesteads. Many Iowans moved to Nebraska, Minnesotans to South Dakota, and so on. Unfortunately, the act was unclearly written so as to invite fraud. Early modifications by Congress only intensified the problem. Most of the land went to speculators, cattlemen, miners, lumbermen, and railroads. Of some 500 million acres dispersed by the General Land Office between 1862 and 1904, only 80 million acres went to homesteaders. Indeed, small farmers acquired more land under the Homestead Act in the 20th century than in the 19th. Homestead Act of 1862, Section 1. Let the following be enacted by the Senate and House of Representatives of the United States of America in Congress. The law applies to any person who is the head of a family. It also applies to anyone who arrived at the age of 21 years and is a citizen of the United States, or who has filed his declaration of intention to become a citizen. Those who meet these requirements must have never fought against the United States government or given aid to its enemies. He shall from and after January 1st, 1863, be entitled to enter 1/4 section or a less quantity of unused public lands. He may enter lands upon which said person may have filed a preemption claim. This is a claim to government land as personal property. Or, at the time the application is made, the land may be claimed at $1.25 or less per acre, or 80 acres or less of such lands at $2.50 per acre. The land must be in conformity to the legal subdivisions of the public lands. Provided this, any person owning and residing on land may, under the provisions of this act, enter other land lying next to his or her said land. This shall not, with the land already owned and occupied, exceed 160 acres. Section 2. The person applying for the benefit of this act must swear that he or she is the head of a family, or they must be 21 years or more of age, or must have served in the Army or Navy of the United States. They must also swear that they have never fought against the government of the United States or helped its enemies. Applicants must swear that the application is made for his or her exclusive use and benefit. The application must be used to actually settle and grow on the land, not to benefit some other person or business. The applicant must file this affidavit or written promise with the register or receiver. They must also pay $10. Then, he or she shall thereupon be permitted to enter the quantity of land specified. There are some exceptions. The land will be issued 5 years after the person applied. If after 5 years the person making such entry, or if he has died his widow, or if she has died his heirs, will need to prove by 2 credible witnesses that he, she, or they have resided upon or cultivated the same for the term of 5 years immediately after the time of the affidavit. Should this happen, that person will need to issue a written promise that no part of said land has been transferred to another person. If this happens, they will get the title to the land. It will be officially theirs. In case of the death of both father and mother, the right to the land and fee will belong to the infant or child they leave behind. The person in charge of the parent's estate may, at any time within 2 years after the death of the surviving parent, sell said land for the benefit of said children, but for no other purpose. At that point, the purchaser will get the title to the land.